Hey everyone, thank you so much for joining us. I am delighted to be moderating this panel, Global Advertising Law Year in Review, to be joined by many of my esteemed GALA colleagues around the world. We're going to be chatting about some exciting hot topics, from influencers to dark patterns to highly regulated industries. By way of introduction, I'm Paavana Kumar. I am a partner at Davis and Gilbert in the USA in our advertising and marketing practice. I really touch on all elements of advertising law, but particularly hot topics such as social media advertising, influencers, subscription regulation, and other regulated industries. Perhaps I will give everyone just a few seconds to introduce themselves so I am not speaking for them. Perhaps, Jose, let's start with you. You're first on this list.
Hi, Paavana. Thank you very much for the invitation. I'm Jose Antonio Arochi. I'm actually from Mexico, and I'm partner at Arochi and Lindner. Thank you very much for the invitation, Paavana.
Of course. Jenny.
Hi there, I'm Jenny Pienaar. I'm from Adams & Adams in South Africa, and we have a long-term relationship with GALA, which we cherish. So it's great to be with colleagues on the panel tonight. Thanks, Paavana.
Of course. Baran?
Thanks, Paavana. Hi, everyone. My name is Baran Güney from Güney Partners from Turkey.
Great. Kanu?
Thanks, Paavana. I'm Kanu Priya, a senior partner with the firm Canu Krishme, which is a medium-sized boutique firm dealing with advertising and marketing laws. And it's great to be on panel tonight. Thank you.
Thanks for joining us. And last but definitely not least, Juan Carlos.
Hello, everyone. It's a pleasure to be among you and with our guests. I'm Juan Carlos Uribe. I'm from Colombia with the law firm of Triana, Uribe and Michelsen. I'm one of the partners in charge of the IP department and advertising law.
Great. All right. Thanks so much, everyone, and thanks for joining us. So we are going to kick it off. We're going to go by topic. Each country will have a few thoughts on trends in their region on each topic. So I'm going to kick it off with influencer marketing. So most of you on the call are probably familiar with the FTC's endorsement guides. I will not bore you with a recap, except that in the USA, influencers need to disclose their material connections with advertisers, so any incentives for influencers to be posting about a brand, and of course any claims they make about a brand or a brand's product need to be accurate and substantiated. What's been really interesting in the USA over the past year is that the Federal Trade Commission, which had previously been pretty focused on influencer marketing, has taken a bit of a step back. They're focusing on other topics, some of which we will discuss today. What we have seen is an increase in self-regulatory actions, both monitoring actions and actions brought by competitors against others in the USA, under the National Advertising Division, otherwise known as the NAD. So that's really where we're seeing this kind of new wave of actions challenging the sufficiency of influencers' disclosures, as well as certain other influencer practices. So here is an example of a case from the end of last year against Drunk Elephant. This was challenging certain disclosures made by Drunk Elephant's partners. Drunk Elephant is a cosmetics brand. As you can see here, this is a skincare example. The NAD found that the disclosure #DrunkElephantPartner was not clear and conspicuous for a few reasons. It was only visible if the viewer clicked on a hyperlink to see more of the caption, so it wasn't in the first 2 lines of the caption. They alleged the words in the disclosure ran together, making it difficult for viewers to read and understand it. That was one of the ones that some of our clients thought, I think Drunk Elephant Partner is pretty good, but the NAD is starting to get granular about things like capitalization and separation of words, and alleging that these kind of run-on hashtags really aren't clear enough. And this third one, which draws on a requirement from the endorsement guides, which is that if any kind of endorsement is being made in both a verbal way and a visual way, the disclosure should really appear in both. So it should be spoken as well as in the text. And that's really not something a lot of influencers were doing prior to this decision or prior to the end of last year, and it's clear that the NAD is focused on that practice. So let's move on to a couple of other examples. So in this case, this was brought against a Revolve group. 2 influencers tagged the company. They just said, @Revolve or #Revolve, but they failed to adequately disclose the actual material connection. In this case, we didn't have partner, we had #GiftedByRevolve. Same allegation, that the disclosure ran words together, making it difficult for consumers to understand. Another post had the hashtag sponsored, but it tagged both Revolve and a different company. Now, we've all said in the USA, hashtag ad or hashtag sponsored is a good disclosure. But in this instance, when multiple brands were tagged in a single post, the NAD alleged it was unclear which brand was actually the sponsor. So if there were going to be multiple collaborations, sponsorships perhaps, where it's not clear which brand is actually the sponsoring entity, that disclosure needs to be very clear, such as sponsored by Revolve or promotion by Revolve. And that's something important to keep in mind. Next slide. So in this case, which is actually something we worked on and I think is really interesting, the NED opened its own monitoring inquiries regarding certain of spokesperson Kevin Hart's influencer posts for Fabletics, as well as some of its other brands such as JP Morgan Chase. Kevin Hart is not only a very well-known spokesperson for Fabletics, he's also an investor in the company. He posts about the company all the time. Hart argued that followers were likely aware of his connections to those brands due to his long-standing public endorsements of them. He'd been the public face of JPMC for over 5 years and an equity owner in the face of Fabletics Men since its launch. I think this is an interesting challenge because at least under the FTC endorsement guides and FAQs that have been published in the US, regulators have said that in certain instances, depending on the context, it might be obvious to a significant portion of consumers that the person is a spokesperson for the brand, and so an additional disclosure may not be necessary. This was an interesting test case where, I don't know if Kevin Hart could have been more connected with these companies, but the NAD still determined that a disclosure was necessary. So at least as of now, the argument that a relationship is so obvious on its face that a disclosure is not necessary doesn't really seem to be holding water, at least in the USA. So we're going to move on. I just have a couple of slides before I turn it over to my colleagues. But something else I do want to point out is that in the US, we're seeing a real increase in class actions over influencer posts. And that's really a new trend. We did not see a lot of class actions brought under state consumer protection laws prior to this year, or at least the very end of last year. And they can be extremely lucrative. So Revolve, actually, the subject of the NAD case I just spoke about, is currently facing a $50 million lawsuit, again over the failure of influencers to disclose their connection with the brand, and also because the plaintiff purported that class members paid a premium for the Revolve products and they proved to be of a lower value than the price paid, but also challenged certain of the claims being made about the products that made them seem better, more effective than they actually were. Another example, Alo Yoga is facing a $150 million class action as well. These class actions can be brought in any state. California is proving to be particularly popular. And I'll just do one last example on the next slide. Oh, maybe I took that example out. So we're going to move on. I think I'm going to turn it over to Stacey. We can skip the slide. No big deal. I'm going to turn it over to Jose to speak about influencers in Mexico.
Thanks, Paavana. Thank you very much, everybody. As mentioned, I'm Jose Antonio Arochi. I'm going to talk a little bit about influencers in Mexico. Compared to the United States, in Mexico, we don't have a lot of case law related to it. But in 2023, Profeco, which is our Mexican FTC, issued the influencer advertising guide. So obviously, it promotes or regulates digital media advertising of all of the influencers. The issue here is that this guideline is not binding. Obviously, it's binding because we've had a big case with one of the biggest influencers that they proved that there was a misleading advertising commercial with Huawei regarding the use or the time the battery of a Huawei cellular phone lasts. They were not able to prove that the time of the battery took in to charge to I think it was 22 minutes, and at the end it was very complicated, and the case has been Profeco against the influencer and against the brand. The issue now is pending because the company, which is Huawei, filed an injunction, and actually because the guideline is actually not very thorough or not very concise, the authority said, you know something, this influencer guide is not binding. It doesn't give all the elements to enforce. So at the end, now there's a precedent that the influencer guideline from Mexico is actually not very complete. So now internally, the Mexican FTC is trying to do something more complete so this doesn't happen, but this is a very good precedent. Just so you know a little bit about influencers and about advertising in Mexico, it's regulated by Profeco, which is the Mexican FTC, and then we have COFEPRIS. COFEPRIS is the Mexican FDA, and everybody's gonna say, why the Mexican FDA? Well, for certain products, certain medical devices, tobacco, alcohol, you need a permit from the Mexican FDA to advertise. Just so you know a little bit about how it is in Mexico compared to the United States. I'm gonna pass it over to India.
Hello. Thank you, Jose. And as far as influencer marketing in India is concerned, the industry has exploded. It's worth about 55 billion INR in 2024, and it's growing faster than ever. So, today's creators aren't just entertainers, they are trusted voices who shape what people buy, eat, wear, and believe. But as their influence grows, one big question stands out. So, are these promotions actually following the same rules as traditional ads? So, to address this, back in 2021, ASCII introduced the guidelines for influencer advertising. And the idea was very simple that if there's a material connection with a brand, influencers must disclose it. They need to use tags like ad or paid partnership. And thereafter, the Central Consumer Protection Authority also reinforced this by making such disclosures a legal requirement. And it wasn't just a self regulatory guideline anymore. So, to see how well these rules were being followed, ASCII carried out a focus study on Forbes India's top 100 digital stars. These were the creators who together had a reach of more than 110 million followers. So the idea was to check how top influencers are behaving. Are they actually following the disclosure rules? But unfortunately, ASCII's report showed that 76% of these top influencers failed to make proper disclosure of paid collaborations. And this number has increased, in fact, from 69% last year. So, in fact, out of 1,173 influencer ads that were reviewed for violation, about 98% needed some kind of modification. The only silver lining was that voluntary compliance is improving. It went up from 80% to 88%, showing that advertisers are increasingly open to correction and cooperation. So to strengthen the oversight, ASCII and Central Consumer Protection Authority have teamed up. ASCII actively monitors online contents, it flags non-compliant ads, and forwards serious violations to CCPA for further action because ASCII is a self-regulatory body. ASCII specially flagged LinkedIn influencers and it issued an advisory in January of 2025 highlighting the increase in non-disclosure of paid partnership by LinkedIn influencers. The advisory reminded creators that failing to reveal material connection violates its code and it also breaches the Consumer Protection Act of 2019. So ASCII clearly reminded that disclosures must be upfront, clear, and prominently displayed and not hidden within a bunch of hashtags or links. And since LinkedIn influencers are generally more educated and aware, they need to acquaint themselves with both ASCII and CCPA regulations. Next slide, please. 2025, ASCII has modified its second addendum to influencer guidelines as well. Under this, the influencers who are giving advice in banking, financial services, insurance, or health and nutrition, they must have proper qualifications. So, for example, those giving financial advice, they need certifications like SEBI registration, they need to be a chartered accountant or a company secretary, while health-related advice requires credentials like being a doctor, nutritionist, or psychologist. So unqualified influencers can share only general information and not technical advice. And ASCII can in fact ask for proof of these qualifications at any time. Another growing concern is unregistered influencers. Basically, their unchecked advice can sway investor sentiment, and it has actually led to a lot of real losses for ordinary consumers. So to tackle this, SEBI took decisive action in January 2025. Instead of chasing every influencer, they targeted the registered intermediaries like brokers, mutual funds, and investment advisors, and they prohibited these registered intermediaries from using unregistered financial influencers for marketing or advertising campaigns. This marks a clear shift from reactive enforcement to structural accountability. So we can safely say that between ASCII, CCPA, and SEBI, India is building a strong coordinated framework, one where advertising influence actually comes with real responsibility. I would like to now pass over to
Jenny.
Jenny. Sorry,
No
I was
problem.
just checking
Thank you
who's
very
next.
No problem. Thank you very much. Don't our flags look beautiful? I just wanted to say that. I think our flags look lovely. But anyway, that's not why we're not here to talk about flags. Can you just go to the first slide for me, please? So influencer marketing in South Africa is regulated under self-regulation only and under the Advertising Regulatory Board's Code of Advertising Practice. It has a number of addenda to the code which deal with specific types of advertising, from pharmaceutical advertising to cosmetics. And recently, in the last 3 years, in fact, the vapor products advertising appendix was only added last year, but the social media and influencer marketing appendix was added about 2 years ago. So before that, there was nothing that regulated how influencer marketing was governed in South Africa. And in the last 3 months, we've received 2 very interesting decisions from the Advertising Regulatory Board. The one related to the breach of the vapor products advertising appendix, and the other one related to the social media and influencer marketing appendix. But in essence, they both dealt with influencer marketing. Nasty Vapes is a producer of vape products in South Africa, and they have an extensive marketing campaign where they get a young, beautiful people to promote the use of the product. And one of the most important clauses in Appendix L deals with underage promotion. And in terms of clause 2 of the Appendix L, you are not allowed to promote or advertise vape products to people under the age of 18, and all people who appear in advertising to promote vape products must at least be 25 years old or appear to be at least 25 years old. So it's very similar to the promotion of alcoholic beverages. Also have that same kind of cutoff age. And what happened here was you had a couple of local kind of TikTok celebrities and influencers who were promoting nasty vapes, but there was no indication anywhere in the TikTok videos, and there must have been about 15 videos. It was the subject of the ARB complaint, that in each one of those, most of the people who were involved appeared to be under the age of 25. Some people even appeared to be under the age of 18, but nowhere was there any indication in the videos that the advertiser, Nasty Vapes, was actually involved or had endorsed or had paid these individuals to run the promotions for them. So the complaint came in the form of a consumer complaint, and the main complaint was that the advertising promoted underage use of vape products. And I'm ashamed to say, as in many countries around the world, it is becoming a bigger problem in South Africa after the sort of clampdown on traditional tobacco product use and in public. And what the ARB had to decide was, number one, is there even a link between the influencers who are promoting the product and the advertiser themselves? And after some extensive research and in-depth examination, they discovered that at least there were, as I said, there were about 15 videos. At least 10 of those videos did not appear to indicate that there was any link between Nasty Vapes, the producer of the vape product, and the influencers themselves. And in fact, what they discovered was that many of the advertising examples were just ordinary individuals, ordinary, but normal people in the street who just decided they were going to use the opportunity to promote Nasty Vapes with a view to trying to engage with Nasty Vapes in the hope that they would be able to sort of create some influencer relationship with them. So interesting ruling from the ARB, and of course at the end of the day they discovered that of the 15, there were possibly only 5 which indicated that there was a direct link between the advertiser, Nasty Vapes, and the influencers, and those particular videos were they asked for those videos to be taken off TikTok. There was a lot of time spent in the ruling discussing the damages and the unhealthy consequences of vaping, and the fact that a lot of these promotions, even though they couldn't find the link between the advertiser and the promoters, just continue to promote the use of vape products by underage people. The second example relates to a breach of Appendix K of the ARB code, which deals with social media. Sorry, if we can just go back. There we go. And that related to Superbalist, is a well-known South African online fashion retailer, and they have a number of contractual relationships with various influencers throughout South Africa. And this particular person, Lily, is one of their influencers, but nowhere on her Instagram post was there any indication that it was actually a paid-for promotion. So the usual hashtag ad, hashtag sponsored wasn't there. And the most important aspect that the ARB considered was the issue of transparency and disclosure in transparency. The advertiser argued in the complaint, which also came from a consumer, that in actual fact the Instagram page for the particular influencer appeared on their website. So if you clicked all the way through to the Superbalist website, you would see that this person had been paid to receive the goods, and the ARB ruled that that was not sufficient, because the average consumer would think that her Superbalist haul, which is a regular feature that they have where the more you shop, the more you get sort of scenario, was in actual fact paid for. So that's all from me on that front. Just as a last word, the Advertising Regulatory Board has they only have jurisdiction over members of the board. So the difficulty comes in where you do get a ruling against an advertiser and you need to enforce that ruling. But we'll chat a little bit more about that later on. Thanks. I think we're over to Paavana again.
Yeah,
Thanks.
that's right. Thank you so much, Jenny, and everyone. That's really fascinating. We're going to shift gears a bit and talk about dark patterns online. Dark patterns are essentially deceptive practices, really just a fancy way for saying things that mislead consumers, but we're going to talk about some developments in various countries. So I will kick it off by talking about some developments in the US. Going to focus on subscription regulation. Primarily because I think it's really interesting. Most of you will probably disagree with me on that, but at least I can say it's very highly regulated in the US, even in the absence of now a consolidated federal law on point. There was a lot of discussion in 2025 because the FTC had proposed a new sweeping, what it calls negative option rule, which would have regulated all subscriptions and all media, online, offline. It would have consolidated a lot of the state requirements into a federal law, which frankly would have made it a lot easier to comply, in my view, with one comprehensive regulation. But in July, the Eighth Circuit vacated the negative option rule on various grounds, including that it might have been an overstretch and not subject to sufficient enough evidence of consumer harm in the marketplace. That said, I think a lot of people expected the Trump FTC not to care about subscription regulation, but I actually think the current FTC cares a lot about practices that defraud the American public, when we cause them to lose money or be trapped into subscriptions they don't want to be paying for. Chairman Ferguson has said the FTC will never back down, especially from taking on big tech. Many of you are probably aware of the big case the FTC brought against Amazon. We'll look at a couple of the other cases from this year. And the basis for the FTC to continue bringing actions for subscription deception, such as people being tricked into signing up for something they didn't want, those will be brought under the Restore Online Shoppers Confidence Act, otherwise known as ROSCA. The FTC can still seek civil penalties under the ROSCA. And under ROSCA, consumers need to be provided clear and conspicuous disclosure of all material terms of a transaction before they provide their billing or payment information. They need to give their express informed consent before they are signed up for any kind of subscription plan, and they need to be given a simple cancellation method, so something that's as easy to do as it was for them to sign up and in the same medium. So on the next slide, I'm going to briefly just touch on state laws. Again, in the absence of a really consolidated federal law, companies unfortunately still need to be aware of laws on a 50-state basis, because the FTC's rules don't preempt state laws that might have more stringent requirements or more idiosyncratic requirements. And just as we saw with influencer marketing, class actions are really on the rise, and companies can be subject to significant penalties based on the size of the class. So this could be its own webinar. I just have a few examples up here, and of course, happy to dive into any of these on the side, but you want to be aware of various state laws. California's is famously one of the strictest, but certain other states such as Vermont, DC, and New York also have their own requirements, such as specific requirements for font size, reminder notices, what exactly has to be in the automatic renewal disclosure, whether or not you need a checkbox if the plan exceeds a month. So for example, if it is an annual subscription. As you can see in the last bullet here, many other states have pending or effective legislation as of 2025, including Minnesota, Utah, and Connecticut, all with their own requirements, including regarding cancellation and when and how you can try to save a consumer, for example, with an additional offer or a survey or something like that. So certainly a real patchwork to deal with, and you have to be aware of state AGs, consumers, and the FTC. So I'm briefly just going to go through a couple of actions to illustrate the FTC's focus on this. So this is a case from 2025. The FTC brought an action against Uber, alleging that it charged consumers for Uber One without their consent. It didn't deliver promised savings. So for example, it said when you sign up for Uber One, you're going to save X% versus if you don't sign up for Uber One, but that savings claim didn't factor in the actual cost of the subscription. So it was effectively illusory. And it also made it difficult for users to cancel the service despite its cancel anytime promises. So that was a pretty straight action under ROSCA. And so Uber ended up having to settle with the FTC. Go through a couple of others. So the FTC again brought actions against both LA Fitness, which is a California-based gym membership, and Chegg, which is an education tech company. The FTC alleged in the LA Fitness case that LA Fitness made it very difficult for consumers to cancel their automatically renewing gym memberships. I like both these cases, and the Uber case is illustrative because just in 2025, the FTC is obviously not focusing on any one specific industry. They're going after Uber, they're going after gym, they're going after edtech. So they're really looking at this across all industries and really conducting an industry-wide sweep. I think some of these practices are especially egregious. For example, with LA Fitness, consumers had to go to the gym and they had to visit one designated staff member who may or may not have been in that day in order to cancel. There was no online way for them to cancel or a different way. So that's really egregious. They didn't let people quit the gym. And in Chegg, consumers were signed up for subscription services that they didn't want, and they had to go through a relatively labyrinthine cancellation process. So just an example, in the US, doesn't really matter what size company you are. There's certainly technology companies are more under the radar. The FTC is being pretty aggressive about policing subscription practices under existing laws. I'm just going to spend a second on the next slide because I think it's really interesting as a new kind of dark pattern. But what we are seeing is new state laws around practices such as algorithmic pricing or dynamic pricing. So dynamic pricing is a strategy that bases products or services prices, either on evolving market trends or consumer data. It could be how many people are currently on the website. It could be day of the week. It could be another AI algorithm. So New York's one of the first states to enact a specific law around this, which requires most businesses using personalized algorithmic pricing to include a clear and conspicuous disclosure that that's what they're doing. So the disclosure has to say, this price was set by an algorithm using your personal data. I'm sure companies will be delighted about having to use that disclosure, but it has to be placed on, at, or near the displayed price. And it has civil penalties of up to $1,000 per violation, which really could be per consumer or per misleading ad, which when you think about it, based on how many consumers are being served on an e-com website, that can really add up. And the AG can enforce it without a consumer needing to bring a private right of action. So stay tuned on that. I'm sure next time we do this webinar, I'll have more to say about that. But for now, I am going to turn it over to Jose to talk about dark patterns in Mexico.
Thank you very much, Paavana. Well, at the end, everybody knows what's dark patterns, but what I wanted to tell you is that in Mexico, there has been amendments to the law regarding dark patterns. The new provision establishes that service providers must clearly disclose whether the acquisition of a service involves automatic recurring charges. Like everybody knows, in Mexico, advertising law is very limited. At the end, as we are a civil jurisdiction, we are based on different laws. And in Mexico, everything related to advertising law was just established in one article of the Consumer Protection Law, which was Article 32, that this talks about misleading advertising. So now that things are getting more up in scale, and there's so much issues like dark patterns that are coming into the equation, and there's a lot of consumers that are filing complaints before the Mexican FTC. That's why there has been an amendment that was approved by the Senate not long ago. It was maybe like a month ago or a month and a half ago. So now we have something regarding dark patterns. What you guys have to understand is that in 6 months we have the World Cup, and there's going to be a lot of issues regarding dark patterns, ambush marketing, different issues that at the end in Mexico they were not very known, if you want to say it in that sense. But at the end, there's going to be so much consumers that are going to be misleaded, that a lot of us private practice have been talking to the Senate to try to amend the law. So we have not just an article talking about misleading advertising, but also about dark patterns, but also about other issues related to advertising law. So just so you know, now it's a big step. I'm always saying that Mexico is in diapers regarding advertising law, and it's true compared to the United States and other jurisdictions. But at the end, this is a very big step, that we now actually will have something included in Article 76 of the law that is established regarding dark patterns. So I turn it to India.
Thank you, Jose. And well, in India, the regulation of dark patterns has progressed from theoretical guidelines to active enforcement with real consequences. The CCPA, through its earlier guideline in 2023, had identified 13 specific practices as dark patterns, and then on June 5th of 2025, CCPA issued an advisory and directing all e-commerce platforms to conduct a mandatory self-audit compliance. So basically, all e-commerce platforms were required to conduct a mandatory self-audit within 3 months to detect and eliminate all the dark pattern practices which was identified in the 2023 guidelines. So by requiring the platforms to submit a self-declaration of compliance, the CCPA has raised the legal stakes. If a platform declares itself compliant and is subsequently found to be using dark patterns, the violation escalates to potential perjury or deliberate misrepresentation. So far, 26 leading platforms have voluntarily submitted self-declaration confirming compliance, a clear indication that the industry recognizes the seriousness of CCPA's intent. And CCPA has also imposed financial penalties on companies, establishing clear precedents for dark patterns, especially drip pricing and basket sneaking. I would like to pass over to Jenny.
Kanu, in the South African context, if we could just move to the first slide, I always say that we don't have, it's a bit like a black hole. We don't have any regulation at the moment on dark patterns. And I know that our Advertising Regulatory Board is actively trying to work towards creating an appendix, as they've done with other important aspects of marketing. So they do create regulation in relation to direct marketing, but there's nothing in relation to dark pattern marketing. So where we do have to turn to then to try and establish whether or not there's been any form of dark pattern marketing is to the Consumer Protection Act and to the Protection of Personal Information Act. These are relatively new pieces of legislation which, although their dates go back to 2008 and 2013, they only became effective several years after they had been drafted. And our Protection of Personal Information Act is really very similar to the European data protection legislation. So it makes provision for an information regulator, and it has certain guidelines relating to direct marketing. Specifically, it deals with the difference between opting in and opting out of direct marketing, and it also provides for a distinction between electronic and non-electronic marketing. So, for example, non-electronic marketing in the past would have been post or direct contact with people. For example, if you're in a supermarket and someone offers you a product and says, "Would you like to try this?" And then electronic, of course, being anything that was via electronic media, email, WhatsApps. Under the Consumer Protection Act in 2008, telephone calls, for example, would have fallen into the non-electronic marketing division. And if we could just move to the next slide, we had earlier this year, the information regulator provided an update to direct marketing, and there were certain amendments that were provided for, which means that telephone contact now becomes part of electronic marketing. And the reason why that's important is because the opt-in and opt-out rules are very different. So whereas something would have been regulated differently under the previous provisions, it's now changed. What has also been introduced is that the National Consumer Commission, which manages the information regulator, has now provided a registry for preemptive opting out of direct marketing. So as a consumer, you can enter your details onto this registry, and then nobody, that's what they say, is allowed to contact you. So I can tell you I've tried it and I'm still getting irritating phone calls from people. But I did learn in the process of preparing for this webinar that I did not realize that telephone marketing fell under electronic marketing. And so therefore there are different rules that apply. So I encourage consumers to become aware of their rights. One of the other things that's very important that's come out of this opt-out registry is that it's placed quite a big onus on direct marketers to check the register and to cleanse their own databases vis-a-vis the register to make sure that they're not contacting people. You know, these are all great rules to have, but frankly, when the Direct Marketing Association of South Africa is involved in the direct marketing register, you do ask yourself how well that's going to turn out. The National Consumer Commission, of course, can only use the information as the guardian of that registry, can only use that information for the registry purposes, so updating the registry, making sure that the information that appears on the registry is up to date. They're not allowed to share that information with anyone. And the best thing for consumers, I think, because we all get endless phone calls about updating our insurance and our trackers on our motor vehicles all the time, is that you can now opt out of direct marketing before being contacted. So yes, it is a space that requires, I think, greater regulation, the dark patterns, because there isn't anything that actually even defines that in our either at self-regulatory level or at statute level, but let's hope that we can see some changes coming in the near future. And I think it's now over to Juan.
Well, yep. Okay, welcome everyone. Let's go to the slide. The case that we're going to talk about has got to do with two famous brands. Got to do with Movistar, which is the largest mobile telephone provider in Colombia, and an offer that it made with Netflix. Basically, the reason why this had a lot of press and bad press for the parties involved is that Movistar came with an offer in which it told its consumers, hey, we have this great offer for you. Come, join us, and you will have Netflix free if you pay this additional value price. Run. Yeah, so it sounded very nice, certainly, because it will be like saying, okay, well, I get a subscription for my mobile, and I get a Netflix subscription likewise at the same time, and I'm paying for the two with a slightly higher price. Great. But as it turned out, when obviously there was a link whereby the consumer had to go and register for the Netflix subscription with a code provided by Movistar, but when they came to the nitty-gritty of the situation, it was for, next slide please, it was for 3 months. So it was like, Wait. One moment. I thought I was getting the whole deal together. I was paying for my mobile. I will be getting my Netflix at the same time. And obviously it was, no, just 3 months. I mean, that's what we mean by free. You will have 3 months free. And well, they took the case to the Superintendency of Industry and Commerce, which is our local FTC. And basically they put a hefty fine on them for local standards, which was about $250,000. And certainly that sent a message, regardless, this sort of not very clear offers in which free must be free. I mean, capital letters, everything, not just free for a while. And that's the case that we have for you to talk about this case of complete information. Next one. So basically, yeah, that's the summary of what we've been telling you about how the information you provide is complete. And now to Paavana.
Great. We have Baran next, I think, right? Somehow we managed to go back. Here we go.
Thank you. Hi again. The theme of this year has been a focus on dark patterns in terms of subscription models and the use of personal data in marketing, but which I will talk later under another section. The advertising board, next slide please, has issued several landmark decisions this year. I can briefly summarize to you. First, let's talk about the definition of dark patterns under Turkish law. It's not defined by the law, by the way. The practice is aligned with global trends in prohibiting designs, interface designs that manipulate a consumer choice. The advertising board is prioritizing dark patterns, especially in subscription flows, cancellation process, and some free trials. The first major decision, next slide please. The first decision is against a on-demand broadcasting company, which is Gain Media, the name of the company. The decision is about the subscription cancellation methods offered by the company. The board found two problematic practices in this cancellation method of the company. First, interrupting the cancellation flow. Consumers clicking cancel subscription were faced a full page promotional content unrelated to the cancellation. On the right side, you can see the page for cancellation. They offer a variety of TV shows, movies. They provide a best selection. I think this is kind of a drama saying don't leave us. And the second, the actual cancellation button was buried in the website content. You can barely see it at the bottom of the page. So continue cancellation button appeared only at the bottom of the page and in a very small font. So the board found this practice misleading and considered this as a typical type of a dark pattern because the design of the website, of the web page, diverted, delayed, and discouraged cancellation from consumers. So this is considered type of a dark pattern. The board ordered for a cease order and administrative fine against the company. In the next slide, I can talk about another decision about dark pattern imposed against Google for YouTube Premium subscription page. The board actually, in the past, in 2024, had already sanctioned Google for the same YouTube Premium page, but a follow-up investigation continued in 2025, and they ordered for non-compliance, a cease order, and again, administrative monetary fine. The key findings in the investigation and the decision include, first, the preselection of the individual plan. it comes as pre-selected. So the board considered that the consumers were steered toward the most expensive option. This is the most expensive option, I understand from the findings of the decision. And the second, a mandatory payment card information is needed, even for free trial. So the board emphasized that a free trial shouldn't require card information because it is free. It should be free. So there's no need to, the board considered that there should be no need to enter card information and to make a subscription based on the card information. And third, it is considered unequal presentation of choices in the mobile app. We cannot see it here because it is reformed, transferred, redesigned. Consumers not wishing to accept a 2 months free offer had only a small X button to close the screen, but this was positioned away from the main selection area. So the board considered these practices created expectations inconsistent with a genuine trial and restricted consumers' choice, and this is a manipulative interface design, according to the board. Thank you. I think we will pass to another topic. Right.
Yes, we're going to get through some data privacy developments. We do have a couple of topics we'll get through as much as we can, and I guess we'll just have to do part 2 if we don't get to everything. But I think Jose is going to kick it off with data privacy topics in Mexico.
Thank you, Paavana. At the end, online data and privacy technology developments, there's been a lot of movement in Mexico regarding different advertising, the changes of advertising on how companies and influencers are advertising. Obviously, there has to be a valid consent and transparency always. Here in Mexico, we had an authority that was just regulating online data privacy issues. Now it was the authority was foreclosed in a way, and now it's part of it's part of another authority. But we're starting on seeing some enforcement regarding some data privacy issues. The opt-out for marketing communications will be simple, permanent, and free, just so you know. But there's a big dilemma on who's going to be the enforcer, if it's going to be this authority, which is Función Pública, or is it going to be Profeco? So just so you have a little bit of an idea of how data privacy is being moved and how are things done in Mexico regarding data privacy, obviously on the advertising business, no? Online data privacy, like I was mentioning, is Profeco, which is the Mexican FTC, and INAI. INAI doesn't exist anymore. So it was a very solid authority with a lot of teeth regarding data privacy. Now, the new government terminated with this authority, and now it's part of a very big entity that regulates everything related to corruption. So there's an area of this authority, which is, like I was mentioning, Función Pública, that regulates data privacy issues. So again, obviously, this coordination between authorities is rising, and like I was mentioning, it was these two authorities. There is parallel proceedings from privacy and consumer and advertising. Again, like I was mentioning, it can come from Profeco, which is the Mexican FTC, or it can come from the new INAI, which is Función Pública. Transparency in influencer marketing when personal data is collected or used is very important. And over collection or non-necessity of data under the data minimization principle is very important. At the end, I think our authority regulates more, or there's more enforcement on the privacy area, on the privacy section, than on consumer protection, unfortunately. But let's see how, when there's advertising or different campaigns that include privacy issues with advertising, how things develop, and let's see how much case law comes into the equation. I'll turn it to India.
Thank you, Jose. I do have a lot to talk about data privacy in India because data privacy landscape has undergone a fundamental transformation since the enactment of Digital Personal Data Protection Act, which marks India's transition from fragmented sectoral regulation to a comprehensive unified data protection framework. So this act actually established a rights-based, consent-driven approach to personal data protection. And the operational framework of the act was in fact finalized in November 2025 with the notification of the rules. So the act mandates that personal data can be processed only with data principles, free, specific, informed, unconditional, and unambiguous consent. Any technology that collects or processes personal data must operate with explicit user consent. When processing personal data for advertising, the data fiduciaries must provide privacy notices that include an itemized list of personal data which is being collected, the purpose for collection, and the process for withdrawing consent, and how to exercise data rights. It should also inform about third parties with whom data will be shared and the mechanism for filing complaints with the Data Protection Board of India. Children's data is protection under this act represents one of the most restrictive regimes globally. The act defines a child as an individual under 18 years of age. So it extends the protection significantly. And before processing any personal data of a child, the fiduciaries must obtain verifiable parental consent. And this requirement actually goes beyond simple consent. The fiduciary has to observe due diligence to verify that the individual claiming to be the parent is actually an adult legally identifiable under the law. Additionally, the Act imposes absolute prohibition on behavioral tracking of children and targeted advertising to children, and there should not be any processing of personal data that could cause detrimental effect on the well-being of a child. So all of these prohibitions are absolute, and the Act permits only narrow exemptions for health, safety, or education reasons. The Act also introduces consent managers who are actually a single point of contact to enable a data principal to give, manage, review, and withdraw their consent. And significant data fiduciaries are subject to additional obligations under the Act, which includes conducting an annual data protection impact assessment. And so basically for global advertisers who are operating in India, the November 2025 notification of the rules marks the beginning of a critical 18-month implementation window. The first priority for any global advertiser should be to operationalize a multilingual consent-driven architecture. This involves not just unbundling consent for different purposes, but also ensuring the privacy notice is available in all the 22 languages which are specified in the 8th schedule to the Constitution. An exhaustive audit of all data collection touchpoints should be conducted, and for each touchpoint, what data is collected, the stated purpose, what is the current consent mechanism, whether data is shared with third parties, and where data is processed. All of these should be documented, and all the gaps where it is not compliant with the DPDP Act should be identified. The pre-checked boxes should be replaced with explicit opt-in mechanisms. It should be ensured that consent withdrawal is one click and as simple as granting consent. And all third-party vendors should operate under the DPDP compliant contracts, specifying consent, security, breach notification, and data subject rights obligations. The vendor audit should also be conducted by the data fiduciaries to verify compliance. I would like to pass over now to Colombia.
Thank you. So, okay, let's go to, this. Let's go next one. Okay, so this is an interesting case, just maybe due to the nuances. The cases had to do with data protection, how it's gathered. And the case started because an artificial intelligence bot called a lady, a lone lady, to her house and started to ask her questions. And the lady thought that she was talking with a human. Actually, it was a very well-prepared one that was asking question after question, very kindly. And after some time, the robotic call mentioned, okay, I'm a robotic call, thank you for information. We will be updating our database. And this lady felt mistreated. She thought that she was giving consent to a machine, and a consent shall only be provided to another human, and that somehow she was being tricked into talking with somebody that was not a person. So she contacted our local FTC again and told them that she's been misleading because a robotic call passing off as a human is making her provide her personal information, and it should be fine. So our local FTC, the superintendencia, started to look at the information and found out that the robocall had asked her if she was willing to provide her personal information regarding and there will be an award afterwards. And she said, yes, I am. And she said, okay, well, for all purposes and all characteristics, it's irrelevant if whoever gathers the personal information, it's a human, it's a machine, it's a computer, it's an algorithm of some kind. It's irrelevant. What is relevant is when the person is asked if it's willing to provide personal information, they said yes. So in this case, the fact that the robotic call just mentioned at the very end, the fact that it was a robotic call, and at the very end was not akin to making misleading calls. And nonetheless, so the company was not fined, but it was instructed nonetheless to make the disclaimer at the beginning and not at the end. So this is one of those curious cases that we wanted to bring forward. This is basically the summary of what I have just mentioned. So next one. Thank you. Jenny.
I'm a little bit slow off the mark at this time of the night. Thanks, Juan Carlos. If we could just move to the slide. If we can just move to the slide, the first slide in my, there we go. I mean, isn't that a cute little dog? So this ARB complaint dealt specifically with somebody's personal and private information being shared with third parties when they were completely unaware of it. So I suppose in a way it's a little bit of a combination of dark pattern advertising and a violation of your personal and private information. So it was a Facebook page. It was created as what appeared to be a pet insurance company. South Africans love their pets. They like to treat their pets well, and a lot of us have pet insurance as we do have medical insurance. But what happened was the consumer claimed that the Facebook page suggested that the advertiser would actually be the party that would provide the quote and the information relating to the specific insurance program. But in actual fact, the advertiser, who according to the Facebook page is called Cover Bookie, is just a party that is like a third party. They gather your information and then they farm your information out to a whole lot of other financial services providers, including insurance brokers, and they collect a whole lot of quotes for you. And what the ARB had to consider was whether or not the advertising was misleading, because the ARB cannot make a ruling in relation to any infringements of our data protection laws. They can only make a ruling as to whether or not a particular form of advertising is misleading to consumers, and for various other reasons too. And what they eventually found was that the simplicity of the Facebook page, which suggested that if you just click here, because literally there was, as you can see, the picture of the cute little dog. Below that, there's a button, an active button, which says get quote, click here. And then the impression was created that you would get a quote back and then you would be able to decide. But right at the bottom of the Facebook page was a 14-sentence disclaimer, which said, well, actually, we're not an insurance company. We're not an accredited financial services provider in South Africa. So we facilitate the provision of insurance for you. And what the complainant then alleged was that subsequent to clicking on get quote and completing an information form then resulted in her being spammed by any manner of financial services providers who offered her a variety of insurance and banking facilities that didn't relate to her particular inquiry. And in the circumstances, the ARB said that the advertising was misleading and contrary to the code, and they were asked to pull the advert. I think that's the only example that I have in this particular instance. So it's over to Baran, I think.
Thank you, Jenny. I will talk about use of personal data in marketing and the approach of the advertising board. In 2025, the advertising board and the Turkish Data Protection Authority signed a cooperation protocol. This signaled since then a closer scrutiny of how marketing uses personal data. The first case, the next slide please, illustrates this trend. Thank you. The company, which is a retail store, inserted in its user and privacy agreement a blanket consent allowing all marketing communications to consumers. Consumers were not provided with an active opt-in mechanism for this. There was no possibility to withdraw consent and no meaningful information about what would be sent to consumers. The board briefly viewed this as forcing consumers into targeted marketing without true consent of them, and a suspension order was issued. In the next slide, the second decision is about conditioning commercial benefits on personal data. In the second case, consumers buying in a physical store were told they could only access discounts if they share personal data with the company. This included the form, the consent included name, surname, phone number, and age, other personal data, even unnecessary ones. It was not clearly disclosed that discounts were membership only. The company, the retail store, didn't inform consumers about that in an information table or signage or in other advertising materials. As a result, consumers were effectively forced to give personal data in order to receive advertised discounts of the company. In its decision, the advertising board emphasized that consumers must be transparently informed when discounts or promotions depend on membership or data sharing, and consumers shouldn't be placed under pressure to provide personal data as a precondition for benefiting from the discounts of the company offered by the company. The board considered this as a misleading commercial practice and issued a suspension order. This broader enforcement trend reflects that the cooperation between the advertising board and the data protection authority suggests that data-driven marketing will face aggravated scrutiny in the future. Thank you.
Great. I'm going to talk about something kind of privacy adjacent, just something that's a hot topic in the US, agentic AI. Brief aside, for those of you that need to drop, that is fine. We will be making a recording available. If you'd like to hang on, we just have a couple of more topics to go over, but we'll go pretty quick. So in the US, some of you might have heard me present previously on the use of generative AI, for example, for advertising creation and ideation. What we're seeing increasingly, especially for retailers and e-commerce companies, is the use of agentic AI. That really goes beyond the use of just AI agents, but it's really systems that can act autonomously. For example, conducting a start-to-end transaction for a consumer online, which in light of many of the topics we've heard about today, such as binding consumers to subscriptions or other dark patterns, could really present new issues. When I think about challenges with respect to agentic AI, I always say the what, the why, and the how. There are challenges internally of understanding what thought process underlies an AI agent's decisions. They may have been trained on specific business risks or something else, how they may have been calibrated to prioritize certain goals over others, and certainly how companies can determine accountability for the actions of an AI agent and what it might bind consumers and businesses to. So, I think answers to these are the topic of much discussion and much debate, but as companies come up with their internal governance processes, these are the things they need to be thinking about. On the next slide, I have a handy chart that can be made available, kind of showing how AI is evolving and presenting new issues. So a lot of these are also raised by the use of generative AI, but for example, the use of AI to spit out misleading or deceptive claims. For example, if someone is searching for the best of X product online and AI spits out a recommendation that might not be accurate. Another facet to that is sponsor prioritization and bias. So for example, you're on a travel website, you are asking the AI agent to recommend an airline, a vendor, or a product, and you get recommendations based on paid relationships. That has an undisclosed sponsorship risk. It's really not that different from the Google SEO cases. It's just in a different context, and agentic AI is amplifying those types of issues. AI might accept unfavorable terms on behalf of the consumer or by users to purchase it unintentionally. And certainly we have just a whole new bucket of consumer protection issues that agentic AI can present. I want to briefly touch on privacy on the next slide, just because there is such a potential for increased exposure for companies in the US. To serve hyper-personalized ads or recommendations, you need access to more sensitive customer data. So when companies are creating proprietary AI tools or engaging third-party vendors, they have to think about certain things, that they're not violating existing data processing agreements, that their tools aren't scraping or repurposing third-party platform data in violation of third-party platform terms of service, and that their access to personal data complies with stringent state privacy laws. So in the US, there are new privacy laws, it feels like, being introduced every single week, a lot of which might be implicated, but then there are also laws specific to the use of automated decision-making technology, for example, that proposed by the CPPA, and those rules would require businesses to conduct specific cybersecurity audits, perform risk assessments, and provide pre-use notices to consumers before using their data to personalize ads to them. So like our algorithmic pricing law, things are evolving on a pretty much day-to-day basis in the US. So these are important things for companies to be keeping in mind as they develop their governance policies and their AI policies. All right, we're going to do a very quick dive into a couple of regulated industries in Mexico, I think India, and South Africa. So we will start with Jose for a couple of minutes.
Thanks, Paavana. Well, at the end, like I was mentioning, food and beverage advertising, as I mentioned, is not regulated by Profeco, which is the Mexican FTC, but by the Mexican FDA. If you do any type of advertising regarding this particular products, then you need a permit from the Mexican FDA. As I mentioned, COFEPRIS is a primary advertising enforcement authority in the health sector. It's important to mention that beverages in Mexico, if I'm gonna be advertising alcoholic beverages, there cannot be a human being next to an alcohol beverage grabbing the alcoholic beverage, just so you can have it in context. There's some technicalities in Mexico that make it a little bit complicated for our clients when we're trying to do clearance on different advertisings. But as I mentioned, prior authorization in this industry is any product making health-related claims, dietary supplements, which is after pandemic, dietary supplements is something very interesting, and they sell like new bread and alcoholic beverages. Enforcement trends in Mexico, there's a lot of fines for child-directed advertising of products with warning seals. There is a Mexican official norm, which is binding, where products need to have the octagonons saying, oh, there is high sodium, there is high sugar. There's this law that I was mentioning in Mexico. There's a lot of, obviously, products. Mexico, just so you know, is a #1 country in the world with child obesity. So kids are drinking Coca-Cola since they're like 2 years old. They're having very bad food when they're very young. So they try to bring something into effect called NOM 051, which is this Mexican official norm. And at the end, there was a lot of characters in each of the products. So there was, if like the Frosted Flakes, you have Tony the Cat. You cannot use Tony the Cat anymore in the Frosted Flakes. Just so you know, there cannot be characters because the authority says that it incentivizes kids to eat the product, and obviously it's a product that goes against health issues, no? Review and removal of wellness or health claims lacking evidence. As I mentioned, Profeco and COFEPRIS are monitoring social media, not as the FTC, obviously, because there's not so much hands. But if there is a trending topic or there's a big case, obviously you will have Profeco or COFEPRIS behind you. We turn it into India.
Thank you, Jose. There has been a regulatory shift in traditional medicine advertising in India, and all of this revolves around Rule 170 of the Drugs and Cosmetics Rules of 1945. So, back in 2018, when this rule was introduced, it required the traditional medicine manufacturers to get prior approval from state authorities before running any advertisement. So, it was essentially a pre approval system to stop misleading claims. But then in July of 2024, the Ministry of Ayush, which is Ayurveda, Yoga, Unani, and Siddha medicines. So they deleted the rule. They said that this rule was redundant with the existing Drugs and Magic Remedies Act of India. So Supreme Court of India stepped in during a landmark judgment of in Patanjali matter, in which was basically Indian Medical Association versus Union of India. In this, there was a leading brand called Patanjali, which was held accountable for misleading claims. So Supreme Court stepped in and Supreme Court state the omission of this rule in August of 2024. So effectively, they kept the pre-approval. The pre-approval was in effect temporarily to protect consumers from unvetted cure claims. But ultimately, the Supreme Court had to accept the ministry's decision to delete the rule, and they lifted the stay and confirmed that the Rule 170 cannot be enforced because it has been deleted by the ministry. So now, basically, from upfront censorship, the shift has been to after the fact enforcement. But this does not mean open season for traditional medicine ads. Advertisers are still tightly bound by the 1954 Drugs and Magic Remedies Act and the Consumer Protection Act, where the Central Consumer Protection Authority can hit misleading ads as unfair trade practices. So Supreme Court has basically made it crystal clear that no pre-approval doesn't mean no accountability. Over to you, Jenny.
Thank you very much, Kanu. So if we could just move on to the next slide. In South Africa, there's been a lot of activity by several government departments to try and push through various legislation. And if we could just move, here we go. There. So one of the new draft regulations that have been introduced relates specifically to the labeling of plant-based meat products and meat analog products. So in the past, you could call a product chicken style or beef style, and I think largely due to pressure from the South African Meat Producers Association, the government was forced to reconsider the regulations around the labeling of these products because there wasn't any. The provision was made for vegan and vegetarian, but there was nothing that specifically dictated how you would label, for example, a product that looked like a burger, but that was made from a non animal protein product. And the previous regulations were the subject of a lot of dispute, and eventually the matter landed up in the High Court in Pretoria, and the outcome of that was that there was these new draft regulations that dealt with the proper labeling and declaration of these products. So the latest regulation that has come out is that you can now call certain meat analog products and plant-based meat products by their particular description. For example, you can use the word burger, nuggets, and sausages, but you have to be able to say that the product contains at least 9% protein, whereas particularly in a plant-based form. If you can move on to the next slide. We've also seen some movement in relation to the war on plastics and the war on microplastics, and under the National Environmental Management Act, there were draft regulations that were published in August this year dealing with the prohibition of the use, production, distribution, sale, import, and export of plastic microbeads and products that contain microbeads. The difficulty with a lot of these regulations is that the impact of these regulations is quite drastic on certain industries, particularly the personal care product industry and the feminine hygiene product industry that do rely to some extent on the use of these particular products. And we've drafted submissions to government to try and put various cases forward for our clients because the penalties for non-compliance are pretty heavy. If we could move on to the next slide, being mindful of the time. There have also been some developments in relation to the tobacco products control legislation. On the next slide, you'll see, I mean, part of the difficulty that has arisen is that most of our tobacco laws are particularly outdated. So, for example, a tobacco product was always described as something that defined tobacco as being leaf tobacco. It made no reference to nicotine or nicotine-containing products. So the bill was introduced in 2018, and 7 years later, if my maths is correct, we're still debating this in Parliament and trying to get to the bottom of how to define the law and how to make sure that the laws are properly cope with the particular evolution of products in this particular industry, least of all in relation to vaping products and other nicotine delivery systems. Our laws were particularly antiquated. Despite that, we've had very strong anti-smoking laws which have prohibited the consumption of tobacco products in public. And I think that's really where the change came about, was that people said, well, it's all very well, you can't smoke a cigarette in public, but what about all these other products that deliver nicotine but aren't defined as tobacco products? So long and short of it is that the government wants to introduce a complete ban on the advertising of any form of tobacco product or electronic delivery, nicotine delivery system, whether it's at point of sale, including restrictions on use, even in your own home, if there are minors around. The introduction of plain packaging, most of you have seen that already, and it's not a surprise for you in various countries around the world. And the war on that, from a trademark perspective, has been fought and lost in several jurisdictions. So thank you. I think that's it. That's the wrap.
Great. Thank you all so much. Thank you, everyone. Being mindful of time, we did have one question in the chat. It's for Jose, asking if there have been any laws in Mexico specifically in relation to the Football World Cup, specific to ambush marketing.
No,
Would you organizers have to rely on existing general consumer protection laws?
Hi, Paavana. Actually, I'm working on these matters, and actually there's no law, but there's going to be an amendment to our intellectual property law in Mexico, and they are saying that there's going to be an article talking about ambush marketing. The biggest issue of ambush marketing, like everybody of us know, is that it's something that it's time focused. If you don't have tools to bring down advertising very fast, it's useless. So just so you know a little bit, there was a case not related to football, but in Mexico, the Mexico City Marathon is sponsored by Adidas. The day of the marathon, 6:40 in the morning, all of our Fifth Avenue was packed of Nike advertising. So at the end, what happened? Nothing. The damage was done. So we're trying to have tools for our clients, for the official sponsors, for FIFA, for them to not have any issues when the World Cup comes here in 2026. Because obviously, as we are a very informal market, everybody will be using Paavana advertising to obtain a benefit without being official sponsors. The lady selling quesadillas on the corner, the guy selling tacos on the corner, or the guy trying to fix cars, they're gonna try to get an advantage. So it's gonna be very important what Consumer Protection Profeco does and what the Mexican PTO does.
Great. Thank you so much. If anyone has any other questions, all of our information is here. You can also get it from GALA. Please feel free to reach out to any of us. But otherwise, I would just like to say thank you, everyone, for participating. That was a really fascinating panel and contributions from everyone. And thanks, everyone that joined us today.
Thank you. Thank you all.
Thanks, everyone. Thanks, Paavana.
Hey, thank you.
Bye.
Bye, everyone.
Everyone.